The lead speaker for our second session is Professor Geoffrey Miller, the Stuyvesant P. Comfort Professor of Law and Director of Center for the Study of Central Banks at New York University School of Law. He was previously the Kirkland and Ellis Professor at the University of Chicago Law School for 12 years and has been a visiting fellow or scholar at the University of Frankfurt, Sydney, Australia, Basel, Switzerland, the Center for Economic Research in Tilburg, Holland, and the Bank of Japan. Professor Miller has his bachelor's degree magna cum laude from Princeton and his JD from Columbia, where he was editor-in-chief of the Columbia Law Review. He then clerked for Carl McGowan on the United States Court of Appeals for the District of Columbia and for Justice Byron White on the United States Supreme Court. Our first commentator on Professor Miller's presentation will be Professor Robert Hockett of the Cornell Law School, the faculty of which he joined in 2004. His primary interests are in the fields of organizational and financial law and economics. He previously worked for the International Monetary Fund and clerked for Judge Dinel Tacha, then Circuit Judge, now Chief Judge of the United States Court of Appeals for the 10th Circuit. He has his BA and JD degrees from the University of Kansas and a master's from Oxford and an LLM and JSD from Yale. The second commentator on Professor Miller's presentation will be Joseph Bauer, Vice President and General Counsel for the Lubrizol Corporation, with which he has been affiliated since 1992, since 1985. Mr. Bauer has his bachelor's degree and JD degree from the University of Toledo. So Professor Miller, whose presentation is entitled Gatekeeping by Contract, Policing Corporate Misconduct. Geoffrey.
Thank you, George. Also, you left out one of the most important parts of my introduction, which is that I'm also a student of Harvey Goldschmidt. Harvey, you don't remember this, I think, but when I was in law school, Harvey, I believe you were just barely out of law school yourself, but I viewed you as extremely wise at the time, and you've only gotten wiser since. Well, George introduced this morning with the question, where were the lawyers? And that's really the canonical text of today's event. It was famously asked by Judge Stanley Sporkin in a decision growing out of the Lincoln Savings and Loan scandal that was written in 1990. He asked, why didn't at least one lawyer blow the whistle to stop the overreaching that took place in this case? Well, that question asked in 1990 seems even more pertinent today in light of Enron and related scandals. Where were the lawyers who served Enron? Where was Vincent and Elkins? V&E had been Enron's lawyer for many years. Enron was Vincent and Elkins' largest client, accounting for millions of dollars of billings each year. Hundreds of V&E lawyers worked on Enron deals. Surely, might be asked, surely in the course of that work, V&E must have had knowledge of the massive fraud at Enron. Many of the deals that V&E attorneys worked on were later shown to have been instrumental in perpetuating the fraud. V&E's attorneys were first-class business lawyers with world-class reputations. They were not naive. Is it possible that they didn't understand what happened? And if they did know or should have known, how is it possible that they stood by and did nothing to stop the problem while it metastasized into a disaster? V&E itself was a world-class law firm with a stellar reputation. So if V&E stood by while Rome was burning, what about other firms? This is obviously a disturbing set of events. Now, I'm not here to impugn V&E or any other law firm or to accuse anyone of misconduct, but to illustrate the motivations behind the recent upsurge in proposals to enlist lawyers, as well as other so-called gatekeepers, to serve as watchmen for the public in detecting and preventing corporate fraud and misconduct. Now, the natural outrage that follows from disclosures of misconduct, such as occurred at Enron, at WorldCom, and other companies, tends to lend credibility to extreme proposals for reform. But it's important to not let the understandable emotions that come from the disclosure of these terrible acts cause us to engage in a response that is an overreaction. We really need to try to put what happened into context and ask a couple of questions. One is, has anything really changed? Was anything really different in the 1990s than has been going on all along? Because if nothing really changed, then a dramatic response may not be as indicated. And second, if something really changed, was what changed an ephemeral event that is something that happened but is time limited and unlikely to happen again soon, or was it something relatively permanent, something which isn't going to go away for a long time? So I'm going to ask those three questions. The first thing, has anything really changed? The human tendency to commit fraud is as inbred as a dog's instinct to steal food. Even the best bred dog at the Westminster Dog Show will steal food if not watched by its handlers. If people are given the means and resources to defraud others and believe they can get away with it, they will do so. And the recent wave of corporate scandals may be unusual in dimension, but not in kind. There were plenty of securities and accounting frauds in mining companies and railroads in the 1890s, land speculation deals in the 1920s, the savings and loan industry in the 1980s. And lawyers have, perhaps for equally long periods, failed to stop such wrongdoing, even when they had the means to do so. When we assess the recent wave of scandals, it's useful to keep this history in mind. So a lot of what we observe in the 1990s really is a continuation of a pattern that has been with us from time immemorial. But other than the extreme magnitude of investor losses, was there anything unusual or distinctive about the recent corporate scandals that we've observed? And I want to suggest that there is something different about what happened in the 1990s. And what happened, what was different, was the product of two forces. One I would class as ephemeral, as time limited, and the other as permanent, something that will be with us for a long time. The ephemeral cause of the scandals of the 1990s and the lawyers' participation or failure to stop those scandals was the stock market bubble of the late 1990s. This really important event in global finance affected lawyers as well as issuing firms and markets. So the stratospheric trajectory of many high-tech IPOs created opportunities for law firms working for high-tech clients to take equity interests in the firms they represented, hoping that the share increase that they expected would more than compensate them for the lack of cash compensation at the time services were rendered. And for a time, they were well compensated for this strategy. Firms serving in the finance industry also profited handsomely from the enormous increase in activity in securities markets during this period. The result for elite law firms was a significant bidding war for quality associates and a big increase in starting salaries. Overhead for law firms became very large, and they had a concomitant need to keep covering those expenses through ever-increasing fee revenues. Law firms had to keep the money rolling in, and that made a compelling difference in terms of how they handled clients, in my opinion. Lawyers and in the high-tech and financial sector also undoubtedly became swept up in the euphoria of the bubble economy. I think this effect is easy to discount because when euphoria has gone away, we tend to forget it. But it was real and important at the time. A share price bubble tends to instill a belief that price increases in the future are simply inevitable. People in the 1990s began to think that things really were different, that the laws of gravity had been repealed when it came to share prices, and that old-fashioned warning signals such as price-earnings ratios could be ignored. The entire market was on a share price-fueled high. And to the extent these attitudes filtered into the legal community, and I think they did to a substantial extent, lawyers tended to be less critical and less cautious when evaluating clients' financing and disclosure policies. Everything was getting better all the time, and therefore relentless optimism was not misleading. So these are, I think, important ingredients in the lawyer's failure to act decisively to prevent the kinds of frauds that we observed. But these were short-lived effects. The bubble could not last, and neither could the bubble-related attitudes and financial structures at law firms. In some respects, this problem has already been rectified with the correction of the bubble. Even though stock prices are now approaching record levels, the assessment today seems to be that valuation reflects a more realistic assessment of underlying quality. But there may have been a more permanent force at work as well in the attitudes and behaviors of law firms. And this is what can be called the evolution of the profession from a club organization to market organizations. That's the headline I want to use, from club to market. And what do I mean by that? Well, a club organization is, as the name sort of connotes, a cozy system of relationships marked by mutual favors, exclusivity, protected markets, and insulation from competition. The American legal profession displayed many features of club organization during much of its history. If we examine the legal profession around 1950, we find club features everywhere. Family connections were a ticket to a good college or law school and a good way to get clients once you set up in practice. Or those connections made in elite colleges or law schools, family or otherwise, were a good source of business, again restricting the market to a small elite. Lawyers in a community were members of the same country clubs and civic organizations as business leaders, and they socialized with one another in all sorts of settings. Competition in club organization, on the other hand, was disfavored. Lawyers who sought to steal other lawyers' clients were stigmatized. Minimum fee schedules were the norm for legal services to individuals. Rules against client solicitation were strictly observed, and advertising taboo. Limitations on job mobility cemented this club form of organization because lawyers typically joined a firm and stayed there for their entire professional lives. Those deemed unworthy of promotion to partner were also protected by being outplaced into corporate counsel's office or sent to a satellite firm that did the elite law firm spillover business. Associated with this lack of mobility in the club organization was a stable structure of attorney-client relationships. Corporations would stay with their outside law firms for years, indefinitely, in fact. These relationships were more stable than most marriages. They were further reinforced by the development of personal connections between attorneys and persons in the client's corporate structure. Typically, junior people in the law firms and junior people in the clients would rise together and get more and more responsibility over time. Relationships were cemented during the course of these careers and further cemented by practices such as the law firm taking offices in the client's headquarters, a very common phenomenon in years past, or the law firm doing extensive personal legal services for senior offices of the client. And all these features of club organization tended to be self-reinforcing and reciprocal, lending a great deal of stability to the system. So now let's fast forward from 1950 to today. And we can see that most of these features of club organization have broken down. Not all. There's still plenty of coziness and lack of competition in some areas of legal services. But for the most part, the club organization has given way to a market-based system. Family connections, no longer a ticket to elite institutions of higher learning, much to the dismay of some who have children applying at those institutions. I speak from experience. Huge numbers of new attorneys have entered the workforce with the addition of new law schools and the expansion of others. In 1951, there were 221,000 attorneys in the United States. In 2000, 50 years later, there was 1,066,000 lawyers in the United States. Even adjusting for population increases, the growth of the legal profession has been staggering. In 1951, there was one attorney for every 695 people. In 2000, it was one for every 264 people. Legal constraints on competition have also eroded. Minimum fee schedules received their quietus from the Supreme Court in 1975. Most restrictions on attorney advertising have been struck down as unconstitutional restrictions on free speech. Rules on solicitation have been eroded but still in place, but attorneys have many ways to solicit business without running afoul of these restrictions, and social norms no longer discourage such behavior. Client poaching is common, indeed expected. Many believe that professional courtesy has deteriorated in other respects as well. The bar, it is said, is plagued by an epidemic of rudeness. Restraints on attorney mobility have also eroded. It's common today for lawyers to change firms several times during their careers. And frequently, attorneys who change firms take others with them, or even whole practice groups. Many small firms have been swallowed up in mergers, unable to compete in a competitive legal environment. What about relationships between lawyers and their clients? The traditional loyalty that used to mark the outside counsel relationship has significantly eroded. Many clients today, in fact, almost all, if they're big, maintain very significant in-house legal capacities, and often they do much of the work themselves. When outside counsel is used, firms are likely to diversify by using a portfolio of service providers. Even Enron, despite its long-standing and deep relationship with Vincent & Elkins, used many other law firms to do its legal work. Large clients are also much more willing to challenge bills or question the quality of work. And clients, too, face competitive pressures due to globalization and legal reforms. For example, the elimination of fixed commissions on securities, dismantling of legal restraints on commercial banking, deregulation in trucking, airlines, telecommunications, electricity, and other industries. So you have more competition in the clients as well. And because of that, clients are no longer squeamish about changing attorneys. What have you done for me lately is the byword today. What about compensation practices? These have changed dramatically. In a competitive environment where clients are constantly shopping among firms, the key to power at a law firm is the ability to attract and retain clients. And this means that the traditional lockstep compensation system, on which attorneys were compensated on the basis of seniority, has broken down and been replaced in most firms by some version of eat what you kill, in which partners are compensated on the basis of how much profits they earn for the firm. And this has had a huge effect on the lawyer's ability to act as independent counselors and monitors of client. In the age of club organization, Judge Sporkin's question, where were the lawyers, had an answer. We knew where the lawyers were. They were the long-standing lawyers for the client. Judge Sporkin's lost lawyer is largely a function of the legal profession's move from club to market organization. So consider this. Under club organization, attorneys had an incentive to monitor one another for quality and ethics. If you're in a lockstep compensation system, the attorney's interest is in maintaining the profitability of the firm as a whole, not just your own practice group or individual client base. And the attorney had an interest in enhancing the firm's reputation because the attorney was not going anywhere. His or her future income depended on the future income of the firm where they currently practiced. The long-range welfare of the law firm was important to the attorney. But today, in an eat-what-you-kill environment, this is no longer nearly as true. Attorneys are compensated on the basis of their own practice groups, and they don't have nearly as much of an interest in ensuring that other practice groups maintain high-quality ethical services. And because attorneys realize that they or others in the firm are likely to move to other law firms, they discount the impact of other lawyers' conduct on their own anticipated future income. So everyone looks after themselves. But this means that it's more possible to behave unethically or unprofessionally and not get caught because you are not being closely scrutinized and monitored by your fellow lawyers. In competitive organizations also, attorneys have less of an incentive to expose their work to others, although Sarbanes-Oxley, as we've heard this morning, may be changing that. Since client contacts are a valuable commodity, an attorney who wants to maximize the value of his contacts will not share clients with others. And this further detracts from the quality of monitoring that occurs in the modern law firm. The problem is only exacerbated as firms grow into thousands of attorneys spread out all over the world, because then even monitoring by a centralized management is likely to be ineffective. And the issue is not only attorney monitoring of attorneys, The move from club to competitive organization also adversely affects the ability of attorneys to monitor their clients. What do you need to effectively monitor a client's activities? You really need three things if you're an attorney. You need knowledge of the client's conduct, the ability to influence the client's actions, and the proper incentives to influence those actions in the right way. The club system accomplished all three objectives. Attorneys had good knowledge of their client's conduct because of their long-standing, deep, and comprehensive involvement in the client's business. For many of the same reasons, attorneys had a good ability to influence the client's conduct. The rich network of relationships that existed under the club system provided attorneys with a nuanced and effective palette of resources to employ in order to encourage clients to avoid testing legal limits. A word spoken on the golf course could sometimes accomplish more than a formal memorandum to the board of directors. And attorneys in the club system had good incentives to use their knowledge in a constructive way. Because of their long-standing relationship with clients, lawyers identified with the client's long-range interests, and lawyers also had economic interests in the form of anticipated future income that promoted a long-range perspective on the client's affairs. Attorneys under the club system were not likely to be swayed by the prospect of a quick fix of a company's financial statements if the result was only to put off even more serious problems until a later day. Now consider the situation under a market system. In a competitive market system, relationships between attorneys and clients are more transitory and based only, typically, on the attorney's formal legal work. Since attorneys do not develop deeper relationships with the client from work or personal interactions, attorneys under competitive system are likely to operate with less knowledge of the client's affairs and institutional processes. The client may also be less willing to share information with the attorney because the two are operating more at arm's length, at least with respect to attorney compensation and retention matters, and because the client may not want to provide the attorney with facts that could complicate matters if the client wants to change counsel. What about the attorney's influence with the client? Also less substantial under the competitive system. Without extensive interpersonal bonds, the attorney may not know how to manage political forces within the client in order to achieve legal compliance and avoid questionable activities. And the attorney's incentives are not well aligned with the long-range best interest of the clients. Lawyers don't identify emotionally with the client as they once did. They're likely to perceive their loyalties as running to the particular officer at the client who allocates the legal work rather than to the institution as a whole, but that officer may be disloyal or may leave and go somewhere else. And the attorney will also discount his or her expectation of receiving future income by the probability that their law firm will be replaced by another law firm, and thus will focus more on producing short-term results for the client rather than on the client's long-range well-being. So what is the upshot of this? The upshot is that attorneys under competitive organization are likely to be less effective monitors of their client than they were under club organization. To answer Judge Sporkin's question, lawyers have left the clubhouse and gone out into the market. Now, I'm not suggesting that we should go back to a club organization of the legal profession, notwithstanding the advantages that club organization posed in terms of monitoring clients. There were many things wrong with the club system: inefficiency, coziness, exclusivity, to name just a few. Like it or not, lawyers are in a market system, and they're going to remain there for the foreseeable future. But we should recognize that market organization carries this cost, that lawyers lose much of their ability to act as wise and independent counselors for their clients and to act as effective checks against the inherent tendency towards fraud that is human, all too human. So this is what I consider the permanent as opposed to the ephemeral cause of the incidents that occurred in the 1990s. Lawyers are not worse people today. They're not less ethical today than they were in times past. But the menu of incentives, social sanctions, and pressures they face may lead them to be less independent and exercise less control over client misconduct. And this is what we might want to think about redressing. Now, I'm going, in just a a few minutes to very briefly discuss some of the proposals, but not do so in any depth given the amount of time. We've talked about the Noisey Withdrawal proposal by the SEC. Now, the metaphor of noise is interesting in this proposal because I think it serves two somewhat conflicting purposes. On the one hand, the idea of noise is that it conveys the idea of commanding attention. Noise gets your attention. So the idea is that when the attorney engages in noisy withdrawal, when the attorney informs the SEC that the attorney is withdrawing due to, quote, professional considerations, the SEC will pay attention. And there's no doubt that the SEC would. On the other hand, the idea of noise conveys the idea of interfering with communication by crowding out meaningful information with signals that are not meaningful. And this term thus conveys the idea that the required action, that is, withdrawal by the attorney, disguises whatever attorney-client confidences may have precipitated the withdrawal. So I commend whoever invented the metaphor of noisy withdrawal for truly brilliant rhetorical skills. But what specifically is required under noisy withdrawal? Well, we've discussed what's required, but the most important aspect is that the attorney, if this proposal were adopted, would be required to inform the SEC that the withdrawal was due to this phrase, professional considerations. Now, that sounds fairly innocuous, fairly benign. Professional considerations. Well, any attorney who withdraws from a client is going to withdraw because of professional considerations. Why else would an attorney withdraw? But in fact, those words, that shibboleth, that mantra of professional considerations carries with it an enormous amount of information because what it tells the SEC is there's wrongdoing going on at the client, I've tried to rectify it, and I can't do it, so you better act. And you can be sure that the SEC will act as soon as it gets that kind of a message from the lawyer. Now, the noisy withdrawal proposal, as has been discussed already this morning, ran into a buzzsaw of opposition from the organized bar. And today, it lingers in a sort of bureaucratic limbo, living a ghostly existence of being proposed but never adopted. So it's sitting out there in hyperspace somewhere as a kind of existing threat, a sort of Damocles that's hanging over lawyers. So does noisy withdrawal make sense? I'll just make a few comments on this and then move to another idea. There are really two parts to the noisy withdrawal idea. One is that it's mandatory. That is, the lawyer has to withdraw if the conditions of the rule are satisfied. And the other is that it's noisy. The attorney has to inform the SEC. Given the transition from club to market organization, it's my opinion that mandatory withdrawal is absolutely essential. That is, the lawyer has lost, in the modern environment, a great deal of the lawyer's bargaining power vis-a-vis the client. The balance of power has shifted towards clients because of the client's ability to replace the lawyer virtually on a moment's notice. So the lawyer doesn't have the kind of club of withdrawal that the lawyer had in the club system, to use the word club in two different ways. The lawyer can't really threaten the client with an effective sanction by withdrawing today because the lawyer withdrawing is simply another example of changing lawyers, and that happens all the time. It will not spark the kind of intense interest that withdrawal of a long-time lawyer would have sparked in the old days. And lawyers also lack bargaining power, so the threat to withdrawal, if it's only permissive, is not going to be very credible. In my opinion, if this proposal is to have any force at all, it has to be mandatory. But what about the fact that it's noisy? And this is a lot more problematic because whatever we may call it, I think there's no doubt that the conveyance to the SEC of the reason for the lawyer's withdrawal will convey attorney-client information. Maybe somewhat disguised, maybe somewhat translated, but there's no doubt that attorney-client confidences are being conveyed when the lawyer makes this communication to the SEC. And that really does fundamentally impact and compromise the traditions of attorney-client privilege. So I'm not necessarily convinced that it's a bad idea, but I think we have to recognize that it's a profound change in the relations between attorneys and clients. Now, there have been some other proposals for how to handle the role of attorney as gatekeeper and how to upgrade that role. Scholars have not hesitated to step in where the SEC has feared to tread. A recent proposal by Professor John Coffey is a leading example. So what does Coffey propose? He proposes what he terms a, quote, big step in converting the attorney into a gatekeeper. His idea is that the SEC should mandate that all disclosure documents filed with it must be signed by an independent attorney, as defined under SEC regulations, who would acknowledge his or her responsibility for the work. And the independent attorney would be required to certify two things. First, that the attorney believed the statements made in the document were true and complete in all material respects. And second, the attorney was not aware of any additional material information whose disclosure was necessary in order to make the statements made in light of the circumstances under which they were made not misleading. In other words, the 10b-5 standard. And the Coffey proposal is essentially an expanded version of the 10b-5 letter, which is routinely provided today by issuers' counsel to underwriters at a closing. His idea is that the SEC would amend its rules of practice to deem negligence in the attorney's due diligence in the making of this certification unprofessional conduct. So this is an interesting proposal. Another one, much more onerous, but a version of the Coffey proposal suggested earlier, was by Professor Robert Gordon of Yale University. What Gordon proposes is the erection of a government-certified specialty of attorneys who act as independent counselors. Gordon would require these attorneys, when doing work with significant implications for third parties, the investors, or the public at large, to be the ones performing the work. So a client would have to use one of these independent counselors to do work of this nature. And the independent counselor would not be subject to the ordinary rules of attorney-client privilege and would be permitted or even required to inform the appropriate government officials about serious violations of law. Now, Professor Gordon's idea is way too radical to enjoy any realistic chance of implementation in the foreseeable future. Professor Coffey's certification proposal, on the other hand, does have some prospects of being adopted, at least in part because it purports to do no more than require an issuing firm's counsel to make the same representations with respect to periodic disclosures under the 1934 Act as is already done by private market convention for new issues of securities under the 1933 Act. Well, these ideas have some attractive features, but they do suffer from the potential defect that they impose mandatory duties on clients and attorneys to one degree or another, to a substantial degree in Professor Gordon's proposal of independent counselors, to a lesser but still notable degree in Professor Coffey's certification 10b-5 approach. And to this respect, they're inconsistent with the attorney's traditional role of undivided loyalty to the client. Clients who know their attorneys will be performing due diligence on the client's compliance and then communicating the results of that due diligence to the public and the SEC may legitimately fear that the attorney's interests will not be perfectly aligned with their own. And this leads to another possible variant on the general approach of enlisting the attorney as gatekeeper. This has been proposed by a number of people, but never really thoroughly explored. In this version, no new obligations would be imposed on attorneys or clients. No sticks would be used to induce compliance, but instead the reform would be facilitative and permissive. The basic idea is that clients would be encouraged, but not required, to enter into voluntary retainer agreements with attorneys that would authorize the attorney to act as a gatekeeper. The approach would utilize carrots rather than sticks to achieve the public policy objectives. Under the terms of the retainer agreements, clients would selectively waive in advance the attorney-client privilege and the attorney's duty of confidentiality for situations where the attorney has observed serious actual or planned misconduct within the client, has taken the problem to the highest authority at the client, and failed to achieve a proper rectification of the problem. In such a situation, the lawyer would not only be permitted, but in fact would be required under the terms of the contract with the client to inform the appropriate government agency about the misconduct. What would the government's involvement in this proposal be? Well, quite limited. The government would hopefully undertake to assure that the limitations on the waiver of attorney-client privilege would be respected. In other words, that selective waivers would be respected, and thus not lead to any broader abrogation of guarantees of confidentiality. The government could also define the criteria that qualify a retainer agreement as a gatekeeper representation, and the government could undertake to give credit to clients who implement such agreements, in the event that the client is ultimately held responsible for legal violations involving conduct subject to a gatekeeper agreement. This could include, for example, special credit under the Justice Department's sentencing guidelines, or allowing the presence of a gatekeeper agreement to be a mitigating factor in the assessment by agencies of fines or civil money penalties. But an equally important incentive for adopting voluntary gatekeeper agreements would not be governmental, but rather private. Because clients would be expected to disclose such agreements to the market, the investing community would have the opportunity to assess whether the agreements add value to the firm, and if so, reward the firm's managers with a higher share price. Managers could be expected to approve these agreements if they wish to assure the market that their companies have strong commitments to complying with the law and truthfully disclosing their financial condition. This idea of voluntary gatekeepers is not really very thoroughly fleshed out, nor is it necessarily something that would gain much appeal to those who actually make policy. Nevertheless, it might be a useful addition to other proposals in the literature for enhancing the attorney's gatekeeper role and providing a higher level of compliance. If it's successful, it would provide a better answer going forward to Judge Sporkin's question, where are the lawyers? Thanks.
Very interesting proposal and very interesting analysis of where we are and of some other proposals that have been made. Our first, I have one other point though, Geoffrey, about one of your initial statements. We do have several students attending, and I could see that they share your outrage over the rise in starting salaries. Our first commentator is Professor Bob Hockett.
Thanks a lot for the invitation. It's a great pleasure to be here, and indeed an honor to be here with so many distinguished co-panelists and co-participants. I'm going to say just a little bit about why, or what I find attractive about Professor Miller's proposal, or at least the proposal that we at least look into the prospect or consider seriously the prospect of voluntary gatekeeper agreements. And I'm going to say what I like about it by explicit reference to certain features of the current public debate over the attorney-client privilege and the work product doctrine, because it seems to me there are certain features of that debate that are accountable for by reference to certain uncertainties, empirical uncertainties that infect the discussion. And it seems to me that Professor Miller's proposal might indeed speak directly to or directly address those particular empirical uncertainties. So I'll begin by noting, first of all, that the current debate over attorney-client privilege and work product doctrine in the corporate context is fraught with what seems to me a really surprising degree of irony and overstatement. Okay, so by way of a couple of examples, the executive branch presently, in particular the Department of Justice, not the SEC, of course, sometimes speaks in terms reminiscent of those used commonly by advocates of the inquisitorial, not the adversarial system of justice. You'll often hear advocates for waiver of the privilege talking in terms of the importance of getting at the truth and how if you've got nothing to hide, then you shouldn't be worried about the privilege. Right? The irony in this, of course, is that this is also the same branch that has been notorious about resisting public scrutiny of its internal operations. So, for example, when the public wanted to know who the members of the Energy Task Force were, of course, the answer given was that, well, we don't want to chill the internal discussion, right, that goes on in this task force by revealing too much about what happens inside of it. So we want to we want to view it as being privileged, right? We want to keep that occluded and secret. So that's one irony, right? Another irony, some members of the corporate bar, and here I'm thinking in particular of the hearings that were held by the ABA task force on attorney-client privilege and work product doctrine. Some members of the corporate bar have spoken as though compliance with the law and assurance of such compliance are best viewed as internal matters, right? This is a matter that, well, the firms really want to comply with the law and will be more able to comply with the law if our employees, if all those internal to the firm are able to speak with frankness, right, with candor to the internal counsel, right, and so we need the public interest in corporate right doing is best served actually by the privilege, and of course also members of the bar in some of these proceedings have referred to they invoke the specter of an all-powerful government that's stripping firms and their personnel of their rights, right, and they're appropriating language, in fact, in discussing what's going on that's reminiscent of language that we've come to associate with the advocacy of the ACLU, say, or Ralph Nader. Now, the irony in this set of positions, of course, is that, well, certainly the past 5 years have afforded at least some reason to be skeptical about the adequacy of internal policing by firms and to ensure that their employees are not engaging in wrongdoing. And it also seems a bit fanciful to suggest that the executive branch, particularly as currently, particularly the current personnel who occupy it, are out to get business, right, or are going to sort of systematically strip American business of its prerogatives and rights. The current administration might have appreciated the contributions of Ralph Nader to the 2000 election, but they're probably not going to name him as commissioner on the SEC. So again, a bit of an irony and a bit of overstatement in the usual rhetoric. So then the question becomes, well, how do we account for this? And it seems to me that there are a number of possible ways to account for it, right? Some of them pretty familiar and others maybe more unique to the present context. First of all, part of the story surely just lies in the structure and the nature of contemporary public discourse, which is a discourse that tends to focus on extreme situations, right, and sensational stories and dramatic archetypes whose significance can be telegraphed quickly through in soundbite form, right? Secondly, if you're an advocate of a position, you're going to naturally tend to emphasize the horror stories or the most dramatic exemplars. So all of that is no surprise and quite familiar. But I also think that there's a particular aspect of the present context, the context of corporate wrongdoing, attorney-client privilege, within the corporate context, and so on, that also plays a role in accounting for the ironies and the overstatements. And I think what that is it has to do with the nature of corporate conduct and misconduct itself and its aftermath. And it also has to do with the nature of the attorney's sort of dual role, right, as an advocate for the client on the one hand, but also sort of an officer of the court or of the justice system on the other, and a number of other ambiguities that I'll talk about in a moment. In short, I think what we've got is a particularly acute information problem, empirical information problem, in the context of corporate wrongdoing and the investigation of corporate wrongdoing that lends itself to overstatement in advocacy of one side or another when we talk about the propriety or otherwise of waiving of of attorney-client privilege, or of the work product doctrine. Let me sort of illustrate by quickly noting what the classic arguments are in favor of attorney-client privilege and work product doctrine on the one hand, and then the classic arguments against, or why waiver should be viewed as a good thing, and note how they actually, the extreme positions actually have traction where there is no uncertainty. So, okay, first, on the side of privilege, what's the public interest that's commonly invoked? Well, again, the idea is that, well, you facilitate ex ante compliance with the law within the firm if corporate employees can speak frankly and fully and with full candor with the in-house counsel. What's the public interest in facilitating waiver or full availability of information to prosecutors and plaintiffs? Well, again, we at the very least, we facilitate ex post rectification of wrongs, right? Because you can't do justice without getting at the truth. And indeed, if justice then is done ex post, we're going to provide the right set of incentives ex ante for the future, right? Now, imagine two cases where you have no ambiguity, no uncertainty at all. One is where all personnel within the firm are clearly innocent. There's clearly been no wrongdoing. Well, in that case, it's very easy to argue that the privilege or the rationale for the privilege isn't implicated, right? Because you've got nothing to hide. You've got no worries. There's nothing to, there's no compliance to ensure has been present. So just go ahead and waive the privilege, right? You don't need the privilege. The privilege is only there to hide wrongdoing, right? That's the sort of extreme argument that certainty of innocence lends itself to. By the same token, if you've got clear innocence and no wrongdoing, well, then you can say the advocates of the privilege can say to those who seek waiver, well, there's nothing to gain either, right? You're not going to gain anything. You're not going to learn anything that's going to enable you to enforce the law. All you're going to learn is that we're innocent anyway, so you really don't need us to waive the privilege. In the case of clarity of innocence, again, there's just not very strong. There's not a very strong argument for the privilege or for the waiver of the privilege. Then consider the case of clear guilt, right? Well, here it's very easy to say that the rationale for the privilege, again, isn't implicated because you say, well, if you're clearly guilty, there's nothing to hide. I mean, you've got something to hide. The only reason you'd want the privilege is to hide it. Furthermore, the wrongdoing has already been done, so you can't say we need the privilege in order to facilitate internal, frank discussion to comply with the law. And so, privilege shouldn't be invoked. Likewise, in the case of clear guilt, you can say, well, the prosecutors or the plaintiffs have everything to gain, right, by waiver of the privilege on the part of the firm. And so, again, it's pretty easy to make a very clear-cut, strong case. But now, here's where the problem is. You never have this clear innocence or clear guilt, at least not at the time of the investigation, right? And so it really won't do to argue on the basis of cases of clear innocence or clear guilt for the privilege or for waiver of the privilege. What you've actually got in general in these cases is a great deal of uncertainty and fuzz, so to speak, right? There's uncertainty or unclarity as to the law and its implications. You commonly hear advocates for firms saying that there's been this welter of regulatory growth, particularly post-Enron, and it's very difficult for counsel and for personnel and firms to know whether particular contemplated actions are compliant with the law or not, and so it's uncertain, so you really need that kind of frankness of discussion internally to sort of decide what we've got to do or what we can do. You've got unclarity as to what happened in the wake of something like an Enron or a WorldCom scandal, because clearly there's been a lot of overreaching and there's been lots of incentive then to cover up and to hide. There's a lot of paper to go through, so things, again, are unclear in this case. You've got a certain degree of ambiguity in the role of any counsel and any corporate, including any corporate counsel, as between advocacy on the one hand, zealous advocacy for the client on the one hand, and being an officer of the court and of the justice system and of the general system of enforcement of norms on the other. You've also got ambiguity as between information, which isn't privileged anyway, on the one hand, and mere advice or lawyerly opinion on the other. Sometimes it's not very easy to draw a bright line between those two. And then finally, you've also got ambiguity in the case of waiver of the privilege as between voluntariness of the waiver on the one hand and coercion of one degree or another on the other, in particular because in the cases where We're talking about a waiver in order to be deemed cooperative in the investigations, thus to enjoy the benefit of lighter sentencing. And of course, corporate counsel often have said that, you know, even though it's voluntary, it doesn't seem to feel that way. Waiver often seems coerced to one degree or another. Now, in these cases where you've got this systematic ambiguity and this uncertainty, then it's very clear that there really is room to benefit, for the firm to benefit, and for the public policy interest in corporate compliance with the law to be advanced through honoring of the privilege, right? It's at least plausible. One can make a colorable claim to the effect that, well, if you do encourage, right, free and candid discussion within the firm before possible wrongdoing takes place, you do presumably, at least to some degree, enhance the likelihood that the firm is going to be compliant. But by the same token, in these cases where there's ambiguity and uncertainty, it's also the case that it's quite plausible to hold that a waiver of the privilege and full revelation of information to the prosecutors or the plaintiffs will also afford something to the public interest, right? You better enable those who are prosecuting claims to find evidence of bad faith or good faith, and there's more opportunity for more red flags to be raised so that those investigating are able to find out where to look, right, more cheaply. But now here's the problem. You've got a colorable claim on both sides in precisely the situations that we're interested in, those where there is uncertainty. But how do you draw the balance, right? I mean, what metric is there to determine how much gain is actually going to be realized by strict honoring of the privilege on the one hand, and how much actually is going to be gained in general, overall, through a liberal waiver of the privilege, or through full disclosure of even colorably privileged information to prosecutors or plaintiffs. On the other hand, there doesn't really seem to be any obvious way to measure these two possible sets of benefits, right? So there's a sense in which we don't really have any clear-cut answer, and this is obviously one reason why courts say that these are case-specific inquiries. But when we're talking right now from the point of view of legislation, in a way, right, we're talking about what should the regime be, what should the system be. We can't just be sort of case by case, right? We have to think in terms of aggregates. And we have no way of aggregating the respective values on the two sides. So we're stuck with this dilemma and possibly this sort of endless cycle of extreme argumentation on both sides, platitudes on both sides, each set of platitudes of which is plausible as an initial matter, but is irresoluble, right? Now, this is where I think Professor Miller's proposal becomes quite intriguing, right? Because what we're talking about here is ex ante waiver, which means, of course, it's not coerced. You don't have the case where the waiver is being made on the basis where under the sword, right, being wielded by a court or by a prosecutor or an agency. So there's no ambiguity about voluntariness. But I think maybe even more importantly here is that insofar as there is measuring to be done as to what the comparative values are of waiver on the one hand and privilege on the other, strict observance of privilege on the other, what better aggregator of that sort of value information is there than a deep and liquid securities market itself, right? Insofar as it's buyers of shares who are actually primarily interested, and that is the primary public interest, I take it, that's in the backs of our minds when we're talking about the enforcement of corporate norms anyway. And insofar as the waivers are indeed voluntary and ex ante, and insofar as you've got an active industry of analysts out there looking into the various value prospects for firms, I can't imagine any better aggregator and measurer of the comparative valuation to be afforded by ex ante waiver of privilege or limited waiver of privilege than the securities markets themselves. So I think that this is a proposal that's very much worth exploring. whatever side one is on in the current debate as to whether privilege ought to be strictly honored or waived. A couple of other things I had to say, but I think I'm going to waive those for now and maybe come to them later.
Well, okay, we will probably have some time later on, but first our second commentator, Joe Bauer.
Thank you. Professor Hockett focused on the attorney-client privilege issues, and I'm really going to go back a little more, I think, to some of the concepts that Professor Miller articulated on his theories on how we got to where we are, which is in a pretty interesting place, I think, at the moment, post-Enron, a little bit of time, reforms underway principally but not exclusively through Sarbanes-Oxley. And I certainly found his article, which is in your materials, very thought-provoking, this concept of how the profession, the legal profession, has changed from more of a club atmosphere, as he articulates it, to a more market-driven business model approach. And I certainly agree with that. I think I would use different words to describe the progression. I think it's moved more from a highly professional and personal advisor role that counsel traditionally viewed itself as occupying, a role of a balancing wheel to the client, to the organization, to the leadership of the client. It's moved from that to much more of a technical, mechanical, kind of optimal specialization role. There's an element here of from generalist to specialization. I think it's been perhaps an inevitable development, but a very unfortunate one. Unfortunately, I think when you move from general to specialist, sometimes you can lose some common sense in the translation. I had a lawyer tell me once, we were debating all of these things, and he was an outside counsel. I have a lot of regard for him. And we kept coming back to the practical problems we were facing. And he said, you know, the law department really is in charge of common sense. And I wound up sharing that thought with my own chief executive officer, and happy he agreed with it. Of course, he said it's a good thing you have some of that, because you don't know engineering and you don't know product selling, and you're a generalist, so I'm sure you're not really that technically knowledgeable even in all of these areas of law we deal with, but we do expect you to be able to, as he put it, smell a dead fish. You know, and I think the profession has gone, you know, we've lost some of our olfactory skills. I don't know how we did it, but it's kind of sad. And we do need to get back to it. On the attorney-client privilege, you know, I would just vary onto that just to say that in my experience advising senior executives and directors over the last 20 years, the attorney-client privilege is an awful lot dearer to the hearts of lawyers than it is to clients. Most of them are not very interested or patient with all the intricate distinctions between work product privilege and qualified and absolute. The bottom line is they want to do almost every time the right thing. They tend to have an awful lot of common sense, these business decision makers. When the SEC proposal for Noisey Withdrawal was being proposed energetically, and as you were right, it sure hit a buzzsaw. I was interested in it. I was in the clear minority, I think, of general counsels. I would favor it. I would strongly favor it, and I took the time to research many of the comment letters that were submitted by law firms and general counsels. I even called a couple of them that I know and respect to just peel back the onion a little and challenge some of the assertions, because essentially it came down to two objections. One, you're going to screw up the attorney-client privilege, and two, the states already properly regulate lawyer discipline and leave it to them. So I did a little more research in Ohio, and I can tell you that it's very, very precious few times that there's ever been a disciplinary case, if ever, brought against an attorney for failing to do the right thing and for disclosing or forcing his client to avoid an obvious non-compliant, behavior. In my own view, without getting too inflammatory, the local bar associations don't do that. They're not going to police the advice that lawyers give or fail to give. They're concerned with stealing the client's money, and that's obviously an important problem. You can't have it. But they're not going to have the wherewithal, the resources, or the ability to look at these larger questions about why did not the Enron Law Department, get after these transactions. Incidentally, I have a theory on that specific issue, and I don't know the general counsel personally of Enron at the time. He did come from V&E. He was a corporate transactional partner there. But I do know that they had a highly decentralized legal structure with dozens, literally, of law departments, fragmented and reporting on a direct line basis to business decision makers, and that's an awful long way from the boardroom. There are a lot of structural things that companies can do, and I think many do, to protect against the kind of obvious misbehaviors that characterized Enron. And it's, of course, not just Enron. You can also have very obnoxious and bad behaviors in a business that's a real business. Of course, Enron started as a real business. One of my first projects as a legal person for our company before I was general counsel was the physical construction of a pipeline from a Texas manufacturing plant to the loading docks on the ship channel outside of Houston. And we contracted for what at the time was a lot of money with Enron, and they serviced as the actual general contractor and did a heck of a job. Somehow they got away from that into deriving most of their revenue on all of these complicated financial transactions instead of building real things and providing real services. And one says, where were the lawyers to allow them to get away with that? But you also can say the same thing about Tyco, which was a business with lots of really great businesses. It's probably why it, of course, survived. It really did have real things to make and sell, from fire protection equipment to you name it. There you had a problem of just outright, over-the-top senior most management greed, which leads me to the other comment on how we got here. What did that, when the guy was giving the speech to defend Clinton during the impeachment, and he said, anytime they tell you it's, not about money, it's about money. And we've just gone way too far. Both in the legal profession, and I'm talking about the outside law firm context, and inside in the corporate executive ranks, in different mechanisms. But we have a problem now where for major companies, the CEOs are they're compensated so much that I think they really, and the guy I work for, I really like this guy personally, and we have a very good relationship. But, he makes so much money that I think it's only natural for him to say to himself, if they pay me this much, I must be God. Which reminds me of I love the story of the managing partner of the law firm, and he was being interviewed, and He was in a firm that was not a real democratically run firm where he didn't have to be elected. And someone said, well, this firm is more like a business. You have he said, well, you're more like a CEO. And he said, not really. A CEO has to answer to a board of directors, and I don't have that. So the reporter says, well, I guess you're more like, gosh, it's more like the Pope. And he said, no, the Pope has to answer to God. But there is a point at which when the money is so high, it takes a lot of strong people around someone like that to keep the arrogance factor in line. Because they're thinking, if I'm getting this from these bright directors, they want me to have enormous authority, and that's a short step from doing what I want instead of what makes sense and what's reasonable. The outside firms, though, the billable hour is a terrible thing. The younger generation. I still, even though I'm 53, when I entered the profession, the billable hour was already in place, but not for long. But I didn't know that. I thought it had always been that way. I started at a fine firm, Jones Day, here in Cleveland, and I have it on reliable authority that they didn't do billable hours until like 1975. Before that, it was the old-fashioned method. What was our work worth to you? We'll send you a description of what we did, and you send us a payment that you think is fair compensation. Now, that's a highly personalized role. The only thing I would say I kind of disagreed with or would distinguish from your comments was your feeling that the market model, this business-driven role that the law firms now pay, leads to an impersonal relationship. I wouldn't agree with that. I think that there's way too much schmoozing. There's an attempt to have the interpersonal relationship, but not on the legitimate kind of basis that I think we once enjoyed, where the reason to have the interpersonal relationship and closeness in a former era was so that you could have the rapport to say to the client, you're dead wrong, don't do that, that would be terrible, unethical, and I have too much confidence in you to think you would even consider it after this conversation. Now, the reason for the interpersonal relationship and the schmoozing is because you want them to tolerate another dozen associates on the next project. It's not so that you can tell them the truth. So I would just close by saying when the Noisey Withdrawal proposal came up, I hoped it would do better than it did. I hope it still comes back. I don't think that the law firms are really concerned about the Noisey nearly so much as they are about the withdrawal. They just don't want to have to withdraw. And there are fewer good clients in the public sector because of consolidations. It's dog eat dog, and they don't want to have to, under any circumstance, give up unless they're not paid. Boy, there's no problem withdrawing then. But that'd be my comments.
Thank you. Before getting to questions, and I have one or two myself, I wanted to ask Jeff if you had any response to the commentators' statements.
Well, first of all, I wanted to thank you both. Those are excellent, wonderful comments and really, really insightful and helpful. I wanted to try to put them together in some respects. So, Professor Hockett, you pointed out that issues of attorney-client privilege involve a very subtle trade-off between the benefits of respecting the privilege and the benefits of not respecting the privilege, and that it's very difficult to decide where that line should be drawn because we don't have full information about that. And from Mr. Bauer's comments, I see another kind of trade-off that has the same structure to what you mentioned. And that's between the benefits of specialization and decentralization and the costs of that. So there are benefits to specialization for attorneys. They become more expert. They know what's going on. They have better judgment. They really, really are experts. There are benefits to decentralization within a law firm or within a client. If you decentralize, you give the people in the individual business units a strong personal incentive to make their units profitable, and you can better assign rewards or penalties for performance. So specialization and decentralization are good things, but they have costs, and you insightfully pointed out some of the costs. For specialization, I think you only need to look at our poster child, Enron, to see the cost of specialization. There were excellent attorneys at Enron who were specialized in structured finance. They knew all the subtle ins and outs of the emerging issues task force and all the releases, but they never saw apparently never saw the forest for the trees. They never saw that the deals they were doing for structured finance were fraudulent because they looked at the technical details and they seemed to be okay. So specialization didn't work there. And what about decentralization? Well, Enron was highly decentralized, and that had a certain advantage, but it meant that the general counsel of Enron, who you mentioned, I think his name was Mr. Derrick, who was a good lawyer, but he knew nothing whatsoever about these deals and was totally unable to exercise any kind of responsible supervision about what was done. And by making the attorneys, as you mentioned, report in a line, in a corporate reporting line to the business managers of the individual units, you gave them an almost irreconcilable conflict of interest to serve the interests of their business managers rather than the firm as a whole. So that's a problem with specialization that needs to be traded off against the benefits, and a problem of decentralization. So there's a trade-off that I don't think we fully address, but it's a very interesting one. You mentioned that you favored the Noisey Withdrawal, and that's very interesting to me as a general counsel of an important firm that you would favor that. I also take some comfort in that with respect to the proposal for voluntary gatekeeper agreements, because it seems to me if you favored that, you also would be not opposed to a voluntary agreement of the same type. But let me just finish, and then and then turning to Professor Hockett. Of course, I was delighted to hear that you liked this proposal, and I really thought you brought out an important point, which is that the organized and deep and liquid and well-informed markets are very good at aggregating information, and that this could be one other piece of information they could aggregate. So if we're not able very much in a political and uncertain context to make the trade-off between the benefits of the privilege and the costs of the privilege, by having these kind of ex-ante agreements, disclosing them to the market and letting the market price them, we enlist the advantages of the informational advantages of deep markets to help us in this public policy question. So thank you. That was a wonderful comment.
I want to exercise my prerogative to start with a question myself for you, Jeff, about your proposal. And I'll preface it by saying that I'm aware of the possibility of the nirvana fallacy, that if you say that a proposal is not perfect, that it will not immediately causelessly solve all problems, then it is to be rejected. And so perhaps if your proposal is not perfect, it may still be better than any alternative. However, having said that, I have a concern about the notion of voluntary gatekeeper, because it made me think of other situations where there are contractual arrangements under which somebody is supposedly asked to render an independent opinion or to behave in an independent fashion. And I think in many cases those arrangements are thought not to be terribly effective. One example would be where a corporation, say, has received a hostile takeover bid and says, well, before we reject it, we're going to bring in an investment banker to render an independent fairness opinion. Well, guess what? The investment banker says, I know the answer you want. The bid is too low. Guess what answer I'm going to give you? The price is too low. Other situations, so-called independent outside director in corporate governance, I think we've been flogging that one for years, and without a whole lot of success. the fact remains that if the CEO can influence the selection and retention of outside directors, influence the director's compensation, dictate the information that the outsiders get and so forth, guess what? The outside director is generally going to behave in a way favorable to the CEO. Under your proposal, I could imagine starting up a firm and developing a reputation, Jeff, that we've done an awful lot of this work for quite a while and have never come across a single instance of serious misconduct. And then go around to corporations and say, "We're your boy." Would that be the effect?
Well, whenever you start prefacing a question with the Nirvana fallacy, you know that the question is going to be truly devastating. But I think there is actually a distinction between the situations you mentioned and my ideas. So you mentioned fairness opinions. And an investment bank can, given that it's an appraisal in an uncertain valuation environment, particularly how the Delaware courts have interpreted this function, investment banks have enormous leeway in terms of the appraisals they give, and they undoubtedly do shade their appraisals to respond to what they perceive as the wishes of their clients. I've always been waiting, by the way, for some investment bank to make a mistake and give the high one when the client really wanted the low one, but haven't seen that happen yet. And it's undoubtedly also true that outside directors, while they're supposed to act, in the interests of the company, have a great deal of discretion to favor incumbent management, and often do, too often do. So you draw the analogy between those two situations and the voluntary gatekeeper proposal. The difference is, as I see it, that the risk of liability in the first two situations is virtually nil. So investment bankers, especially as Delaware has interpreted the law, really face no worry that if they give an unduly high valuation, they're going to face liability ex post. Outside directors in Delaware have all, in any big Delaware company, have all been exempted from personal liability for mismanagement. And so they don't have any real worry either. But in the gatekeeper proposal, these retainer agreements would be enforceable in an action for damages ex post if the company failed. The receiver of the insolvent company would have an action against the attorney for a violation of the gatekeeper agreement, which would impose serious potential liability exposure. And I think ex ante, that's something the attorneys would take into account.
Other questions, comments? Tom?
I don't know whether everybody has any data on this, but I'm curious about your insights, and that is whether or not we think the problem is worse today under the market system or better. One can certainly tell a story about the club system that would suggest that a long-time relationship between lawyer and client, or lawyer and officer and client, would lead to a kind of mutual support system, a much greater stake in giving the bad news, that is, I'm going to lose a friend as well as lose a client. And that the market system, being more impersonal, is more likely to lead to better, tougher advice. Do we have any basis for making those judgments other than intuition and being able to tell a story about the move from club to market, which is clearly what's happening?
I mean, I don't have any sort of special information other than intuitions, but there is one thing that it seems worth pointing out here, that it's a feature of the particular markets that we've got now. I think I think Professor Miller's clearly correct, right, that we've moved from club to market. But it's also true, I think, that there are certain features of the market that we have that render the problem maybe even worse, and that I think then might in some ways address your question. And that is that it's increasingly commonly observed by economists that we seem to be moving in the direction of so-called winner-take-all markets, right, a sort of a star system, right, where everybody knows who won the Tour de France, but nobody knows who got second, third, fourth, or fifth, right? So there's this tendency to sort of want to be the best, and not, and even second best, third best won't work, right? And it seems to me that itself, that feature of markets itself is probably a response to a kind of information problem, right? I mean, basically, there are just so many different features by reference to which you can evaluate various competitors in a market, and it's very difficult to reduce all of those features to one, say, common metric. And so we tend then, I think, to fall back on simplified ordinal rankings, right? So everybody looks, you don't really want to know too much about what New Haven is like. All you really care about is that Brian Leiter says Yale's #1, right? And you look at Brian Leiter's rankings, and probably the principal decider for you as to what law school you're going to try to get into is where it is on the ranking, right? And you've got, Letterman's top 10 this, top 10 that, and you've got all these sort of ordinal rankings out there. And insofar as there's this kind of pressure to be at the very top of it, it seems to me that there's pressure just to do whatever it takes to get to the top of it, right? And so my guess would be that insofar as the lawyers have rankings as well, right, and the firms have rankings as well, you're probably going to do whatever there's going to be a strong incentive to do whatever it takes to be thought to be the #1 firm or the #1 lawyer. And I don't know what that says exactly about how much more likely you are to sort of tell your client that he or she is about to get into trouble, but I do think it probably says you're going to worry less about the sort of personal relation compared to what you would have done in the past, and you're going to worry more about what your ranking is, and your ranking seems to largely be a function of the size of the deals you do, right? But
I don't really agree that there hasn't been. I think directors today are much more informed and interested and engaged than they were 15 years ago. I really believe that. There's still room for much more improvement, but they are more independent than they used to be. I think that the emergence of the strong law department is a very positive thing, needs to be implemented into more companies, but I think that an ideal situation that would be better than the present would be continue the improvement of director independence and interest and competence, continue to develop the growth of strong internal law departments, reporting with some measure of independence, through the board, and go back on the law firm model more to the the club arrangement. Fewer lawyers. I keep waiting to see the cartoon someday in the New Yorker where they have the law school canopy that says 1/1000th lawyer graduated. There are just too many. It stands to reason they can't all be as good. You guys are educating them. You maybe disagree, but romantic notion. When I came into Jones Day, it was a huge place. There were 230 lawyers. I thought, my gosh, that they just all seemed to be such terrific lawyers. Now, is it reasonable to think that with 1,800 that they're all good, or do you have some in there for these market-driven reasons?
Very, very quickly. First of all, Bob, I think that you ought to be careful about using the analogy to the Tour de France, because I'm not really sure we do know who won the Tour de France this year. But with respect to Tom's question, your question is, you're not disputing that there's been a significant change in the legal market. What you're asking is, does that change map onto an increased or decreased ability of the lawyers to monitor their clients? And you're raising a question about that, which I think is a very legitimate question. And in a way, George mentioned the nirvana fallacy. We ought to have, if we don't, a name for a different kind of fallacy, maybe the Eden fallacy, which is that things were perfect in the past instead of things are going to be perfect in the future. And things weren't perfect in the past. And in the club organization, it might be that lawyers would often, because they were pals with the client, look the other way if they thought the client was doing something wrong. So I do think that's a legitimate question to ask, and really don't. I think that things have changed. I said it in my paper, but I have to acknowledge that your question is legitimate.
Other questions? Yes. Hold on.
Okay. I'm wondering if this movement toward putting lawyers in the crosshairs isn't motivated by putting medium large corporations in the crosshairs that might compete with multinational corporations. That it's like if you can set up a legal atmosphere, it might attempt to that seems to enforce a transparency among corporations to disclose. Then this might satisfy a lot of members of the center left, and it makes it look like that there's a movement to rein in the corporations, but what this might actually do is allow the big fish, which are the multinational corporations, to eat the little fish, which are the medium-large corporations. Is there any truth to one feeling this way?
Well, I think empirically the evidence so far is that as far as lawyers getting themselves into tremendous personal difficulties is pretty evenly balanced across the spectrum of very large corporations like Tyco and others. I'm forgetting who was Tyco's general counsel. He happened to be acquitted, but he certainly had a difficult experience. And then you have some small companies that have really been picked on. So I don't know. I don't see a correlation between market dominance or size or global character versus domestic. It's just I think the common thread is much more populist, and the public is kind of fed up with lawyers, and it's not new.
I do think it raises the interesting question about whether our policy ought to be different with respect to large firms and small firms, because a fraud at a small firm is to be regretted, but really isn't going to dramatically hurt securities markets or the overall economy, whereas a fraud at an Enron or a WorldCom does hurt confidence in securities markets and the economy. And
right.
that might suggest that there really is a stronger reason to adopt these kinds of reforms for publicly traded firms than for privately traded firms, which has been the case. And even within the context of publicly traded firms, the bigger ones do present a greater systemic problem than the smaller ones.
In that regard, now this isn't quite responsive, perhaps, to the question, but 2 points, picking up on a comment that Bob Rapp made this morning, and what has been a common knock on Sarbanes-Oxley is that the costs fall disproportionately on smaller public companies, with the result, allegedly, that more of them are going private or going dark. Is that something to be regretted, or is that is it the case that if they can't play the game by the rules, then of public companies, they shouldn't be public? And another, and I kind of regret that we do not have an international perspective here, because one other issue that has come up occasionally is whether the costs of registering with the SEC in this country are becoming so high, both the out-of-pocket costs and the costs in terms of relationship with lawyers and such, that it is discouraging foreign companies from listing for trading here. And so I think an interesting question would be, what are other countries doing, and are they having any greater success Should there be a competition among countries? Would it be a race to the bottom, as is sometimes alleged to be the race in corporate law among the states? If so, is there anything we can do to prevent a race of that kind? Well,
I see one question in the back. This gentleman was raised his hand.
Okay, yeah, John, go ahead.
Yeah, well, perhaps I can offer a bit of an international perspective, since the vast majority of my client base are foreign-based companies. And I can tell you there's a race, and we're losing. No question about it. The prospects of companies in the global marketplace who have a choice, not all companies do have a choice, as to whether they will seek listing in the U.S. or listing in London or other very adequate markets. That choice is resoundingly being made against the U.S. marketplace. And indeed, there was a series of articles in the Financial Times this week about how successful the AIM market is, which is the penny stock market in the London Exchange, how successful they have been in capturing market share of IPOs coming out of Silicon Valley. So it's no longer just an issue of what the large foreign public companies wish to do. It's becoming increasingly an issue as to what U.S. issuers wish to do in a market where they have a choice. And the other thing I think ought to be taken into account here, in many quarters of the rest of the world, Sarbanes-Oxley is viewed as just another example of unbelievable American arrogance and hubris. Who are you, would some of my large German clients say, to tell us that for decades our accounting has been inadequate, that our controls have been deficient? Look at the way that we've successfully competed against you in a commercial environment in the world marketplace. And I submit to you that when, as occurred 3 years ago, when George Bush made a trip to Germany, and the very first subject, given all the problems going on in the world, that Gerhard Schroeder insisted on discussing with him was the implications of Sarbanes-Oxley for German-American relations. I think we need to think about whether the ultimate price that we're paying for this sort of creating this sort of regulatory environment, or at least extending it necessarily beyond our borders, is a price that we may, on reflection, consider to be just a bit too high. So that's my 2 cents worth on that subject.
Well, on one hand, it'd be great to continue and pursue that further, but on the other hand, let's leave that. Maybe it'll come up in the third session. It gives you a reason to come back. There should be, Alice, lunches should be available outside, and we will reconvene at 1:30. Yeah.